Good morning, people. This is Jeff with Preserve Georgia Rights again, and I just wanted to take a minute to run through this notice real quick. This is our notice of willful maladministration. In my last video this morning, I gave specific details and instructions on how you can use this tool to exercise your constitutional rights, and I just want to go through it real quick and make sure everybody knows what it says. So this is a notice detailing willful maladministration. We have a case number on there, which is just used for bookkeeping purposes. Should we proceed with affidavits being filed and possibly a grand jury case, that case number will just serve as to just show that each of these documents all are related to the same issue. It states notice to agent is notice to principal, and notice to principal is notice to agent, which basically states that the principal are the people who the notice is addressed to, which is at the top of the page, and their agents would be their secretary or their aide or someone else who may open their mail. And this basically states that you can't say you didn't get it just because your secretary opened it and didn't give it to you. By notice to your agent is the same as the principal having received the notice. Moving on, it says that I, blank, that would be my name, one of the people, as seen in the Georgia Constitution, Article 1, Section 2, Paragraph 1, sui juris, bring the following claims and facts, that you and your agents may provide due care. It is the will of the people to give notice of the true law set forth by the people in the Constitution. There's a lot in that sentence, but it's all necessary. It establishes standing. I'm coming in the standing of one of the people, as seen in the Constitution. I'm not coming as a citizen or as a person or as a government employee or a government personnel. The highest standing in the land, based on the Constitution being the highest law of the land, is one of the people, as seen in the Georgia Constitution, which we will go over below what that states. We, the people, are giving notice of the true law set forth by the people in the Constitution. Basically, this notice, the purpose of this notice is to educate the recipients as to what the law and the Constitution says, and what authority that law gives us as the people to instruct them on what we would like them to do. It is their job to follow the will of the people, not to do whatever they think is best. And I will show you that in the law down below. Second paragraph, take notice that in the trust indenture, which is the Georgia Constitution, government was founded by the people as the beneficiaries. The people are the beneficiaries. And government is based on the people's will. Government was never intended to operate based on the desires or the will of the trustees. Take further notice that the people's right to petition and remonstrate exists because it is the people's inherent right and responsibility to regulate government. When government is functioning in ways which go against the people's will and authority, the people are to correct them and to lead them in ways which are consistent with the Constitution and which redress grievances. See the constitutional provisions below. So now we're going to go into what the true law says. The true law of Georgia, starting with the Georgia Constitution, Article 1, Section 2, Paragraph 1. So Article 1 of the Georgia Constitution is basically what we would call our Declarations of Rights or our Bill of Rights, where the people, when creating the government in the other articles, when the people created the Georgia government and told the government what their rights and authorities were, in Article 1, at the very beginning, we told the government what rights and authorities we reserved to ourselves that the government is never allowed to trample on. So, Georgia Constitution, Article 1, Section 2, Paragraph 1, states that all government of right originated with the people. It is founded on their will only and is instituted solely for the good of the whole. Public officers are the trustees and servants of the people, and are at all times amenable to them. That lays it out, just what we stated earlier. By law, the people have all political power. The government was founded for the benefit of the people. The public officers, government employees, are the trustees, and their job that we've elected them to, or they've been appointed to, is to benefit the people. That's their job, not to do whatever they want, not to tell the people what to do. Their job is to do what the people tell them to do. That's the true law. Continuing on, Georgia Constitution, Article 1, Section 1, Paragraph 9, states that the people have the right to assemble peaceably for their common good, and to apply by petition or remonstrance to those vested with the powers of government for redress of grievances. So those who have been vested with the powers of government, they were vested with those powers by the people, through election, through the Constitution. And the people have the right to apply by petition or remonstrance. Petition is basically common verbiage when they're not talking about a million people signing a piece of paper. But the petition that it's referring to here is when the people petition their trustees basically when we tell them what we want them to do, how do we want them to do their job. Remonstrance is a big word that basically is when we, the people, tell our government that something is wrong and what we want them to do to fix it. So we have the right to petition and remonstrance for redress of grievances. That doesn't merely state that we can tell them what our grievances are and hope they do something about it. It states by law that we have the right to not only tell them what our grievances are, but also to tell them how we want it fixed. Moving on, take notice that all election-related equipment and documents are the property of the people and not the property of the trustees. The trust indenture that you swore an oath to follow clearly states that your primary duty as a trustee is to provide complete and impartial protection of the people's property, and that no one can be denied equal protection under the law. The people have been instructing you to initiate a full forensic audit of the November 2020 and January 2021 elections in Georgia by an independent, non-government team of auditors utilizing only technology created or approved by Jovan Hutton Pulitzer as listed in our attachment. To that end, you as servants and trustees are to provide evidence to the people which proves the people's elections were executed legally and without the threat of maladministration. So what we're stating here is that because the elections are run by the government, because the election equipment was purchased by the government, and the government belongs to the people, then all of this election equipment and documents belong to the people. And the people believe there was maladministration in our election, and we are instructing our servants and trustees to prove to us that there was none. They keep telling us there was none, but we're not asking you to tell us there was none. We're asking you to prove it. Any boss has the right to order an audit of the books of their company. Well, in the Georgia state government, the owner, the boss, is the people. And there's no company anywhere where the boss, where the employees of the company have the right to tell the boss, no, we're not going to audit your books. No, we're not going to look at how we did things. That just doesn't exist. So the people are instructing our elected officials, our servants and trustees, to bring in an independent auditor to audit them to make sure that they did their job right and to prove to us that they did their job right. That's all we're asking. You keep saying you did everything right, but we want proof. We want evidence. We don't have to provide you evidence. You need to provide us evidence that you did your job right without the threat of maladministration. So we go to Georgia Constitution, Article 1, Section 1, Paragraph 2, which states very clearly that protection to person and property is the paramount duty of government. It is their job to protect our property. Do you feel like your property has been protected, your election property? Well, they need to prove to us that it has been. Protection of person and property is the paramount duty of government and shall be impartial and complete. No person shall be denied equal protection under the laws. No person. It doesn't say no majority, it says no person. So if there's a person who feels like they haven't gotten equal protection under the laws, in this case related to elections, it's the government's right, the government's responsibility, their paramount duty, impartially and completely give that person protection under the law. Georgia Constitution, Article 2, Section 1, Paragraph 1, states that elections by the people shall be secret ballot and shall be conducted in accordance with the procedures provided by law. Those two constitutional provisions show that they were supposed to run our elections according to the laws on the books that were approved by the people through the legislature. And all we're asking them to do is to provide an independent audit to prove to us that they did that, to prove to us that everything was handled according to the law. Take further notice, the United States Constitution guarantees all states a republican form of government, and the people in each state are entitled to all privileges of the people in each of the several states. See below from U.S. and Michigan constitutions regarding the people's right to have the elections audited. U.S. Constitution Article 4, Section 2 states that the citizens of each state shall be entitled to all privileges and immunities of the citizens in the several states. Well, Michigan Constitution Article 2, Section 4 states that the people have the right to have the results of statewide elections audited in such manner as prescribed by law to ensure the accuracy and integrity of the elections. What is the purpose? We're not saying the purpose is to overthrow the election. We're not saying the purpose is to have anybody arrested. We're not saying that the purpose is to make them look good for their campaign. The purpose we want is for them to ensure the accuracy and integrity of our elections. That's why we want the audit done. That's why they need to do what the people said. They need to prove to us that the accuracy and integrity of our elections is secure. Moving on to the next paragraph, it's my understanding that you, government officials, elected officials, repeatedly receive telephone calls, emails, face-to-face contact from the people. In addition, you have received numerous notices and sworn affidavits by certified mail or by hand delivery from the people, all of these instructing you to proceed with the election audit as the will of the people. And by not investigating the multiple accusations of maladministration in our elections, you are committing a maladministration yourself against the people. See details of investigatable issues of maladministration attached to this notice. There's an attachment at the end with a list. It is not by any means comprehensive, but it is a list of maladministration accusations that the people are concerned about and the people want investigated. And it's a list of other notices and sworn affidavits that have been filed directing our officials to do this. We have been directing them for a year now to investigate the maladministration possibilities in our election officials. And in this notice, we are letting our state legislature and our state executive offices and our state Supreme Court know that by not investigating the maladministration of these others, they are committed maladministration of their own because they are going against the will of the people. Take notice, as there are no precedents for conducting a forensic audit of an electronically conducted election in Georgia, one of their excuses that they've given us as why they haven't done it is because there's no precedent and there's no rules outlining how it's to be done. Well, that is not true. If you review Georgia Senate Rule 10-4.1, it instructs the Georgia Senate, based on their own rules, and in any case where there is not clear direction on how to proceed, they are to follow the most current edition, and this is a quote from the Georgia Senate Rule, the most current edition of Mason's Manual of Legislative Procedures. The most current edition of Mason's Manual is the 2020 edition. The 2020 edition in Chapter 74, which covers investigations, provides specific guidelines for use by legislative bodies in which to engage investigations covering any issue which they may need to draft legislation later. Well, they're drafting voting laws, and they're going to be asked to change the voting laws, so that's something that they have the legal legislative right to investigate. Mason's Manual also provides legislative precedents for each guideline and clearly shows that the judiciary cannot interfere with the legislative investigation. I'll do another video later over the Mason's Manual. I'll do another video, a couple other videos later going into more details of these laws and how they affect the Georgia citizens, the people of Georgia, so that you'll know what your rights are and you'll know how you can use them in the future. But for now, I just want to get through this particular notice. So he's going to say, take further notice that there is a maxim of law. Maxims are rules and guidelines that are generally accepted by everyone to be true. Well, there's a maxim of law which states that he who does not forbid what he can forbid seems to assent. Since you, our elected officials, have received notice whereby the people believe there was a clear threat of maladministration in our elections, You have been granted the authority by the people to investigate and correct these issues, and you have not taken any action on the people's instructions to correct any of the wrongdoing. Thereby you appear to assent to the wrongdoing. I'm just going to leave that there. I think everybody knows what that's saying. Take notice that when delegating power to the trustees, the people reserved our indefeasible right to regulate our internal government. As a government official, you are always amenable to the people. Here it is in Georgia Constitution, Article 1, Section 2, Paragraph 2. The people of this state have the inherent right of regulating their internal government. Government is instituted for the protection, security, and benefit of the people, and not of the government, of the people. And at all times they have the right to alter or reform the same whenever the public good may require it. Now, how many of you knew that you have the inherent right as one of the people of Georgia to regulate your internal government? Is that news to you? Because it's been the law. It's always been the law. It's in the Constitution, the highest law of the land. It overrides any statutes. It overrides any legislative acts. It says that the people of Georgia have the right to regulate our internal government. We also have the right to alter or reform our government whenever the public good may require it. Take notice, there have been continued delays by the trustees in acting on the will of the people. It is thereby the will of the people that any and all 2020 and 2021 election-related materials, whether paper or electronic, are not to be destroyed after 22 months. All of these materials are to remain intact until the full independent audit is complete. Please take further notice that I, as one of the people, do realize that you, as servants, are not granted authority by any of the 51 constitutions to operate outside the will and direction of the people. As elected officials, you have sworn to uphold the Constitution. Your continued refusal to act on the people's instruction is considered willful maladministration and breach of contract. The Georgia Constitution is a contract. The United States Constitution is a contract. It is a trust indenture, and every elected official, every government official swears an oath to uphold the Constitution. The Constitution says they are to follow the will of the people, and if they are not doing that, they are in violation of their oath and breach of the contract. So what can we do? Where do we go from here? If they continue to act in maladministration, we go on to give them notice, to educate them, that the United States Supreme Court has ruled, as a grand jury is mentioned in the United States Constitution Bill of Rights, and not in any of the first three articles, the grand jury does not belong to either the legislative, executive, or judicial branches of the government, but rather it is a constitutional fixture in its own right. This is from the United States versus Chanin Supreme Court ruling. In fact, the whole theory of its function, the function of the grand jury, is that it belongs to no branch of the institutional government, serving as kind of a buffer or referee between the government and the people. See United States versus Williams. There's a Supreme Court case. Justice Scalia clearly stated that the grand jury should belong to the people as a way for the people to prosecute our government officials if they're not acting right. We go on to say, take further notice that I, one of the people, do realize that the courts seem to have a hard time prosecuting government officials who refuse to follow the constitutional law which governs them. It is hereby my will, order, and demand as one of the people that all grand jury processes be returned to the control of the people, where the people may prosecute all government officials who fail to stand upon their oaths or fail to follow the state and federal constitutions. All state constitutions are created by the people, and the people have a right to have an accountable government. It is no longer the wish of the people that bar association members are in control of who will be prosecuted. Failure to immediately begin the independent audit process is willful maladministration. If it is your intention to continue to act in maladministration, the people would then have a responsibility under the contract terms to remove each of you from office because the public good requires it. Each of you are to be replaced by a new trustee who will obey the will of the people and act in accordance with the terms of the trust indenture, which is Georgia Constitution. Please respond within 5 days if you believe that you do not have the authority to undertake an investigation or to issue subpoenas for witnesses and evidence, or if you have the authority to refuse the people from face-to-face discussions and wrongdoings with the grand jury. Please provide constitutional provision showing where the people have withheld from you that authority. If you do not respond, it will be taken as tacit acquiescence. It shall be understood that you agree with the people's rights given you to institute a full forensic audit of the November 2020 and January 2021 elections, and you agree with the people's right to communicate directly with the grand jury. Any attempts to block this right is done as a trespass, treason, and an attack done on the powers of your trust, again, outside the powers of your trust indenture. And then there's your autograph and there's your date. So we are informing them that the grand juries are supposed to belong to the people, and that we will take back our authority to communicate directly with the grand juries, and we will use them as a way to prosecute government officials who are acting wrongfully if the other government officials will not do that for us as they've been instructed. That's the end of our notice. Hopefully now you understand. If there's anything specific you have questions about, anything specific that you're not sure, you can ask the questions in the comments below. I will try to answer them as quickly as I can. At the bottom we have a CC. These are 3, 4, 5, 6, 7 addresses that you will send the notice to as a CC, a carbon copy. Then we'll go to Attorney General Carr, Sheriff Andy Hester, the President of the Georgia Sheriff's Association, the Georgia Supreme Court Chief Justice, and the United States Supreme Court Honorable Clarence Thomas. So after you fill out the JOT form and you've printed a copy of the notice and you've made 14 copies with your signature on them, you'll send them to the addresses at the top of the page and these addresses at the bottom of the page. On the next page, we have a list of attachments that shows accusations of maladministration that the people have repeatedly asked to be investigated, letting them know what we want investigated and why the people are concerned about maladministration. And we also have a list of previously submitted affidavits directing them to act, which they have up to this point ignored. So anyway, that's my video. This video belongs to you. Hopefully you understand what you're signing. Please share this with as many people as you feel like would also agree and would be interested in exercising their constitutional rights. This notice is a tool. It's a tool that you can use to execute your constitutional right to remonstrate, to petition your government for redress of your grievances. I'll try to come back on here later. If you have any questions, if anybody's not sure about anything, please put them in the comments below, and maybe I can do a video again later just to answer some of those questions. Thank you very much, and have a wonderful day.